Good afternoon, Mr. Skelton. Can Mr. Skelton be heard? Can he hear us?
Yes.
Can you hear me?
Yes, thank you, I can.
Then I'm very sorry. I was seeking to indicate, but by the shortest possible method, that now is your turn to make your opening statement.
Thank you, sir. So, as in Tranche 2, on behalf of the MPS, I wish to acknowledge from the outset the serious wrongdoing by some UCOs and the serious mismanagement by STS and Special Branch managers during the Tranche 3 period, judged not in hindsight, but by the standards that should have prevailed at the time. I'm going to focus today on the 7 failings examined in detail in the MPS's written opening statement. First, managers in the STS, Special Branch and the MPS should not have allowed UCOs to secretly obtain and report information on the intentions and activities of family justice or police accountability campaigns, or information about individual family members. They presented no risk of criminality or public disorder. On the contrary, campaigns such as that by Stephen Lawrence's family actively sought to distance themselves from violent groups and discouraged public disorder. Insofar as senior MPS officers had legitimate concerns about a lack of trust between the police and minority ethnic communities, or about public disorder associated with justice campaigns, having seen, for example, how the Nation of Islam forcibly disrupted the hearings in the Stephen Lawrence inquiry on the 29th and 30th of June 1998, they did not warrant the deployment of UCOs. Instead, the MPS's efforts and resources should have been spent on using non-intrusive methods to engage more with community forums and other forms of local liaison, properly resourcing the prevention and investigation of racist violence, and repairing the relationship between the police and minority ethnic communities. So the contemporaneous documents suggest that reporting on family justice campaigns, including information about Baroness Doreen Lawrence and Dr. Neville Lawrence OBE, was known to senior officers in Special Branch and the MPS, although there is no basis for concluding that any information about them was gathered for the purpose of smearing them in the public eye, as has been alleged by former UCO DC Peter Francis. The inquiry will in due course hear from those senior officers and the STS's managers as to precisely what they knew and whether they authorised such reporting or, as they should have done, questioned its appropriateness. However, it is clear that there was a collective failure to exercise ethical judgment about the purpose of undercover policing and the propriety of reporting on family justice campaigns. This is reflective of an us against them culture that prevailed within the MPS at that time, which didn't properly distinguish between legitimate intelligence targets, such as groups committed to inciting serious public disorder, and illegitimate targets, such as grieving Black and Asian families who are complaining about injustice and the actions of the police. It also demonstrates a failure of corporate governance within the MPS and Special Branch, whose most senior officers oversaw that culture and should have exercised the power to change it. The MPS sincerely apologises to the family of Stephen Lawrence, Dwayne Brooks OBE, the family of Ricky Reel, and the other individuals, families and family members who were the subject of this improper reporting during the T3 period. So second, sexual relationships. As the MPS said at the start of Tranche 2, the sexual relationships entered into by STS UCOs were a gross violation of privacy and human rights. They were abusive, deceitful, manipulative and wrong. The MPS apologises again unreservedly to the individuals whose lives have been and continue to be affected. Further, as the MPS said in its preliminary closing statement at the end of Tranche 2, sexual relationships and the poor management that facilitated them were unacceptable even by the standards of any time and amounted to serious failings. Each such relationship would constitute discreditable conduct and should have been the subject to a proper disciplinary process. The knowledge of the managers of the SDS and more senior officers about these relationships is a matter for Phase 3, and the topic will be considered in more detail then. However, there is considerable evidence that managers within the SDS and Special Branch during the Phase 1 and T3 period either knew or should have known or of at least some of the relationships that occurred. Their attitude to sexual relationships is exemplified by the guidance given to UCOs in the 1995 Tradecraft Manual, which was inadequate, misguided, sexist and offensive. It demonstrated a complete disregard for the sexual autonomy of the individuals who were being deceived into sexual relationships and the emotional and psychological consequences of that deception on them. Instead, its self-serving focus was on the unwelcome, serious consequences for the UCOs themselves. It was also predicated on the false premise that it will be the UCO civilian targets and their associates who will want and initiate sexual relationships, rather than the UCOs themselves. This allowed and encouraged UCOs to abrogate responsibility for their own predatory actions. So it is the result of the efforts of many of the women who were deceived into sexual relationships by UCOs in the SDS and the National Public Order Unit that senior police officers in the MPS and other police services would now be expected to recognise sexual misconduct as an abuse of power and to understand the significant effects that it has on the people who are manipulated and deceived. It is a matter of deep regret that such recognition and understanding was not part of the prevailing culture within the MPS during the 1990s and 2000s. Therefore, no consideration was given at that time, as it would now be today, to contacting the individual women to inform them that they had been deceived. So third, during the T3, P3 period, senior Special Branch and SDS managers repeatedly failed to ensure that the activities of the UCOs were compliant with the obligations of the Home Office 1986 Consolidated Circular to the police on crime and kindred matters. Sorry, I should say the whole of the T3 period. And the applicable SDS policies, which included prohibitions against actively engaging in and committing crimes and against misleading the courts in any subsequent legal proceedings. Examples of this are set out in the MPS's written opening statement. They include DCHN 26's participation in an Animal Liberation Front action in 1998, which involved trespassing on Crow Hill Mink Farm near Ringwood, Hampshire, and releasing between 3,000 and 6,000 mink into the countryside. They also include the arrest of several UCOs in their undercover identities. None of these incidents were handled by the SDS's management in accordance with the Home Office circular or the policies then in operation, and several of them involved misleading a court, which was wholly improper. It should have been obvious to the senior police officers aware of those arrests that they mustn't be managed in any way that involved misleading a court, and that in many cases decisions about disclosure were required. Evidence about these issues will be heard in Phase 3. So fourth, in Tranche 3 there was a general failure on the part of the SDS's management to impose discipline on UCOs. Officers who behaved unprofessionally or dishonestly were not subject to misconduct proceedings, and there was no proper recognition that their lack of professionalism and integrity created security risks which made them unsuitable for further sensitive work within Special Branch or elsewhere in the MPS. This led to a culture in which misconduct was tolerated wrongly in order to protect the continuation of the secret work of the unit. And as set out in the MPS's written opening statement, the handling of DS Thompson's misconduct exemplifies this failure. So fifth, the use of deceased persons' identities. In November 1994, the SDS ended regular use of the identities of deceased individuals to form false undercover identities. The prompt for this change was the advent of computerized birth and death records in the 1990s. However, the method used by the SDS after 1994 could and should have been used earlier if the SDS's managers had considered the ethical propriety of using deceased persons' identities. The MPS wishes to repeat the apologies it made at the end of Tranche 1 and the start of Tranche 2, and to extend those apologies to the families of the people whose identities were used by SDS officers in Tranche 3. I'll quote, "The MPS accepts that the managers of the SDS failed to recognise the hurt, distress and anger that the use of deceased children's identities would cause the families of the children and the public concern that would result if the practice had been revealed. It apologises unreservedly to the families for this. It also wishes to acknowledge that their distress will have been compounded by the revelation that some SDS officers behaved indefensibly while using their children's names. So as Mr. Barr has explained, when DS Thompson was in Special Branch prior to joining the SDS, he obtained a copy of the birth certificate of a child, Kevin Crossland, who had died with his mother and sister in an aeroplane crash in Yugoslavia in 1966. After DS Thompson joined the SDS, he then used that birth certificate to obtain a driving license and to create a second false identity. There was no justification whatsoever for the misuse of Kevin Crossland's name and identity in this way. As set out in the MPS's written statement, the MPS respects and supports the objectives of Lisa Crossland and Mark Crossland, Kevin Crossland's relatives, to get answers and accountability for why and how this happened. So sixth, welfare of UCOs. By the early Tranche 3 era, there was an increasing awareness, both within Special Branch and in the wider intelligence community, of the unique stresses and risks to mental health that could be caused by undercover work. Work was done to improve welfare for UCOs in the 1990s, but too often the operational security of the unit took priority, and in general, there was a failure to recognise the significant psychological effects of undercover work, including the constant stress of living in a false identity, and for some, the direct experience of physical violence or the chronic fear of being exposed and physically attacked. The MPS regrets that it took until 2001 to implement compulsory professional psychological support in the unit, which was one of the most important and effective welfare measures for serving and former UCOs. It acknowledges that some UCOs, including DC Francis and others, suffered significant psychological harm as a result of their work, and that more could and should have been done to prevent this. So seventh and finally, I turn to the spouses, partners and families of the UCOs. Undercover deployments always placed great stress on UCOs and their spouses and families. This was particularly the case in the SDS, whose deployments lasted several years, far longer than routinely required of officers deployed in other fields. UCOs were required to work long hours away from home, living in their false identities every working day. Security risks and fear of exposure also led to some UCOs and their families having to undergo the upheaval of relocating their homes and lives to protect their and their families' safety. However, the severity of the negative impact on spouses, partners and families was contributed to by the SDS manager's failure to provide sufficient support and psychological welfare, which exacerbated the mental stress suffered by some UCOs and thereby damaged their ability to readjust and function normally at home. The sexual infidelity of some of the UCOs also caused serious harm to their families, which was similarly contributed to by managers' failures to prevent sexual misconduct from occurring and to discipline the officers concerned. So some of the spouses of the UCOs in Tranche 3 are or have been core participants in this inquiry, and it's understood that one of them may give evidence at the forthcoming hearings. The MPS wishes to apologise unreservedly to them and to all the partners and former partners of SDS UCOs for its failure to better protect them from the effects of the SDS's work and the misconduct of its officers. So may I finally say this on behalf of the MPS. Undercover policing is an extremely valuable means of gathering intelligence for the purposes of protecting national security, preventing serious crime, preserving public order, and other important public policing purposes. It is, however, an exceptionally invasive form of policing that should only be used where the need for intelligence is sufficient to justify the high level of intrusion into the lives of the individuals targeted and those not targeted who are subject to collateral intrusion. Undercover operations also necessitate high standards of conduct, ethics and governance on the part of UCOs and their managers. This is essential to avoid the unacceptable risk that the tactic will be exploited for improper purposes or that UCOs will act unprofessionally and abuse the positions of power in which they are placed. During the 1990s, as in previous decades, some of the SDS's targeting was justifiable and some UCOs produced valuable intelligence during challenging and at times dangerous deployments. But some of the SCS's deployments wrongly gathered intelligence on individual groups and campaigns that should never have been the subject of undercover reporting. As I have stated, some UCOs also engaged in disgraceful conduct that warranted but didn't receive the strongest disciplinary response from senior officers. Due to a lack of proper management, they also engaged in criminal conduct and with the criminal justice system in ways that were inexcusable. In short, sir, the SDS became a dysfunctional undercover unit. The human toll of the SDS's dysfunction has been severe and wide-ranging. Misuse of deceased people's identities, wrongful intrusion into individuals' private and political lives, grievous sexual exploitation, damaged relationships, broken families, and widespread anger, distress, and psychological harm, including to some of the officers themselves. So the MPS recognises how important it is to understand the damage that the SDS has caused, to hear directly from the people who have been affected, and for the inquiry to hold those responsible to account. Thank you, sir.
Thank you very much. The opening remarks that you have just made are entirely consistent with those that you made in the opening parts of Tranche 2, and I and others will be pleased to hear them reiterated and to be reiterated authoritatively on behalf of the Commissioner. Thank you very much.
I'm grateful, sir.
As you know, there is an issue that I intend to raise with Mr. Sanders for the DL team, and I would ask that you should listen to what is said, and I will give you the opportunity of saying anything in consequence that you may wish to.
I shall. Thank you.
Thank you. Do you want me now to rise while we reconstitute, or do we go straight on to Mr. Sanders? We can resume straight away. Right, we're good to go.
Sir, I hope it's me you're intending to hear from next and not Mr. Sanders. I think I'm down on the schedule.
I do apologise. I've got myself in a muddle, and I was in fact expecting to hear from Mr. Sanders, but that's my mistake. Please continue.
I'm very grateful, sir. So in fact, we're very grateful in the first place for the opportunity to make this brief oral opening statement on behalf of the Secretary of State for the Home Department. In her capacity, as you will be aware, as a core participant, as distinct from her role as the sponsor of your inquiry. As you are also aware, sir, we've provided you with a set of written submissions, which we hope will be of some assistance.
Yes, I have them and I read them. Thank you.
I'm grateful. So this is the first opportunity that the current Home Secretary has had to make submissions to your inquiry. And so whilst this has been said before on behalf of a number of her predecessors during the life of the inquiry, let me make clear at the outset that the Home Secretary is appalled by the historical allegations under consideration by your inquiry and considers it vital that we now swiftly get to the truth about what happened and ensure the appropriate lessons are learned for the future. As you've just heard from Mr. Skelton, undercover policing is a crucial tool in tackling serious crime and keeping the public safe, but there is and never can be any excuse or justification for the type of conduct that is at the heart of this inquiry. And although the process will inevitably be difficult for many of those concerned, particularly those whose lives have been irreparably damaged by the misconduct of undercover officers, it is important that these matters are subjected as far as possible to unsparing public scrutiny, and the Home Office will continue to cooperate fully with that process, as it has done since the inception of your inquiry. All that said, sir, the extent of the direct involvement involvement of the Home Office in the subject matter of this tranche of the inquiry's hearings, focused as they are on the Special Demonstration Squad officers and civilians affected by deployments between 1993 and 2007, would appear to be small. No Home Office witness appears on your witness list for this tranche of hearings, and no statements have been requested from former Home Office ministers or officials. That position entirely reflects our understanding of the current state of the Tranche 3 Phase 1 evidence, or at least that part of it with which we have been provided to date and have thus been in a position to analyse. That analysis, sir, enables 2 points to be made at this stage in respect of the role of the Home Office in the subject matter of this phase, at least, of the inquiry's work. First, whilst the Home Office appears to have remained a recipient of indirect SDS intelligence, we have not seen any cogent evidence of direct tasking of the SDS by the Home Office. This is consistent with the evidence considered in tranches 1 and 2. As noted in the former Home Secretary's opening statement for the Tranche 2 Phase 2 hearings, paragraph 34, there was a single witness who suggested that there may have been Home Office involvement in determining whether a group or individual was subversive, namely HN 78 in his statement of April 2022. HN 78's evidence was to the effect that the Home Office, or the Home Secretary, it wasn't entirely clear, deemed the Socialist Workers' Party a subversive organisation and or must have considered the SWP appropriate to infiltrate. However, when questioned by your counsel on the 31st of July 2024 about the basis for his view, HN 78 did not identify any evidence to support his assertion, and nor is the Home Office aware of any corroborating evidence from any other source. So that was the only piece of evidence that even suggested direct tasking. And so by the conclusion of the Tranche 2 hearings, the evidential position was that there was no cogent evidence of SDS tasking by the Home Office. That remains the position on the current state of the Tranche 3 evidence which we have seen, and as it stands today. In the event that any witnesses suggest during the course of this phase of the hearings that tasking of the SDS by the Home Office did occur, we have no doubt at all that any such suggestion will also be rigorously tested by counsel to the inquiry, and the basis upon which it is made clearly identified. So we also have no doubt that counsel to the inquiry will keep clearly in mind that the government is comprised of numerous different departments and agencies, of which the Home Office is only one, and we would invite the same care to be taken on this issue by all other participants in the hearing. On several occasions during your Tranche 2 hearings, there were questions and or references to, quote, the government, without it being made clear whether the reference was intended to relate to the Home Office specifically or some other branch of the government instead. The Home Office should not be seen as shorthand for government in general or as a euphemism for the security services. And if it is being asserted by anyone that Home Office ministers or officials did something or knew something, that needs to be clearly stated so that the assertion can be properly understood and tested. So the second general observation on the evidence is that at the time of making this opening statement, the Home Office is not aware of any evidence to suggest that the Home Office or any Home Office ministers or officials were aware of, firstly, instances of SDS officers being involved in criminality within the Tranche 3 period. Secondly, the use of deceased children's identities to form undercover legends. And or thirdly, the particular issue of sexual misconduct of SDS officers. In addition, there is no evidence that we have seen that the Home Office or its ministers or officials were aware of conduct by SDS undercover police officers leading to miscarriages of justice or potential miscarriages of justice. So you've heard me make these points before on behalf of the Home Office in earlier tranches and phases of the inquiry, but they are critical, as you will recognise, for my client, and so I do not apologise for making them again. It is important that everyone keeps in mind my respectful submission, what the evidence does, and perhaps more importantly, does not demonstrate in this regard. So that is all I propose to say about the evidence at this stage at least, but there is one further matter of substance which I would like to address you on briefly, if I may, by way of opening submissions, and that concerns the legislative and regulatory framework of policing during the Tranche 3 period, i.e. 1993 to 2007. We have set out the position in our written submissions, and I don't propose to rehearse the detail this afternoon. The inquiry will no doubt be aware of the legislative background, and we will make our, and no doubt will make our written submissions publicly available in the usual way. But I do wish to emphasise the significance of what occurred during the Tranche 3 period in this respect, because it represented a radical reform in the way in which the deployment of undercover officers was authorised and regulated. In particular, we see in this period a fundamental shift away from the conduct and deployment of undercover officers being regulated by an aggregation of non-statutory guidance, codes of practice, judicial precedent, towards a framework of statutory standards and requirements. The key legislative development in this regard was the Regulation of Investigatory Powers Act 2000, RIPA, which came into force in October 2000, right in the middle of the period with which you are currently concerned. The purpose of RIPA was to ensure that the investigatory powers to which it applied were used in accordance with human rights, in light of the coming into force of the Human Rights Act 1998 at about the same time. Part 2 addressed surveillance and the conduct and use of covert human intelligence sources, CHIS, and it introduced for the first time a statutory scheme for the authorisation of informants and undercover police officers. By section 29(2) of RIPA, the activities of a CHIS could be authorised if 3 requirements were met. These concerned firstly the authorisation's necessity, secondly its proportionality, and thirdly the oversight of the CHIS in question during authorisation. The legislation was extensive and detailed, and I'm conscious, sir, that you will be very familiar with it from this inquiry and from other work in which you've been engaged over the years. The short point, for present purposes, is that it reflected a recognition of the need for a clear statutory framework to ensure that rights were protected and standards were upheld. The same impetus is reflected in the legislative development specifically concerning the police. The Tranche 3 period saw the introduction of the Police Act 1997, Part 3 of which introduced for the first time a statutory system of regulation with respect to police interference with property, use of listening devices, and wireless telegraphy. The Police Conduct Regulations of 1999 came into force on the 1st of April that year, and they established an investigation procedure for where a complaint or allegation that a member of the force did not meet the appropriate standard was received by the chief officer of the relevant police force. That procedure included the appointment of an investigating officer who was required to produce a report which could result in a hearing being convened, following which the officers conducting the hearing had the power to impose sanctions up to dismissal from the force. Schedule 1 to the regulations contained a code of conduct for police officers, which included requirements of honesty and integrity under paragraph 1, which applied whether the officer was on duty or off duty, and stated, "It is of paramount importance that the public has faith in the honesty and integrity of police officers. Officers should therefore be open and truthful in their dealings, avoid being improperly beholden to any person or institution, and discharge their duties with integrity. Further, under paragraph 12, entitled General Conduct, it stated, whether on or off duty, police officers should not behave in a way which is likely to bring discredit upon the police service. On the 1st of April 2004, towards the end of the Tranche 3 period, the 1999 regulations were revoked and replaced by the Police Conduct Regulations of 2004, which were to broadly similar effect and incorporated equivalent standards. So in addition to those significant developments in terms of primary and secondary legislation, the Tranche 3 period also saw the substantial progress in the promulgation of codes of practice and guidance relating to the authorization of CHIS, including undercover officers, and the work of special branches more generally. The Covert Human Intelligence Sources Code of Practice 2002, known as the CHIS Code, was issued pursuant to Section 71 of RIPA and applied to every authorization of CHIS under Part 2 of RIPA, providing guidance on the use and conduct of CHIS by public authorities. This CHIS Code, which has since been updated on several occasions, outlined the procedures for authorizing and handling information obtained through CHIS, ensuring compliance with the relevant legislation and human rights. It echoed the requirements in RIPA, and it gave guidance for the authorizing officer. In particular, perhaps, and of relevance at this stage of the inquiry, it required that, firstly, when considering authorizations, the person granting an authorization must believe that CHIS use is necessary for a legitimate aim and proportionate to the intelligence being sought. And secondly, consideration must be given to the risk of collateral intrusion on the rights of individuals who are not direct targets. The Tranche 3 period also saw the promulgation in 2004 of the Home Office guidelines on the work of a special branch in Great Britain. The guidelines reflected what they themselves described as, quote, radical reform in this area, and they contain a neat summary of the key developments over the preceding years at paragraph 3, which, if you'll forgive me, sir, I'll read out because it's a shortcut to what is otherwise quite an extensive legislative set of developments. Since the publication of the previous guidelines in 1994, several significant legislative changes have taken place within the United Kingdom. Most notably, the Human Rights Act came into force on the 2nd of October 2000, incorporating the key provisions of the European Convention of Human Rights into the United Kingdom domestic law. This legislation clearly regulates the activities of public bodies such as the police service, including special branch, across the United Kingdom. Moreover, the covert activities of law enforcement agencies have seen radical legislative reform with the passing of RIPA and the Regulation of Investigatory Powers Scotland Act. Special branch staff, like other members of the police service, must comply with these pieces of legislation. In particular, and in support of the overriding principle of protecting human rights, the use of the powers and authorities provided to the police service by virtue of these acts are regulated, subject to inspection and oversight by 2 independent commissions. Special branch, as with all other areas of policing, is subject to the provisions contained within the Data Protection Act and, more recently, the Freedom of Information Act. The guidelines also emphasised the nature and extent of the threat, which had clearly developed following 9/11, and the continued importance of human source reporting in meeting that threat. So, sir, the introduction of a statutory framework for the authorisation and regulation of undercover policing, along with the associated guidelines and codes of practice, were in no way indicative of a reduction in the threat to the public or the importance of undercover policing in helping to meet that threat. They reflected instead the recognition of a need for clear and enforceable standards in order both to meet changing societal expectations of policing and to prevent findings of violations of rights under the European Convention on Human Rights. So by way of final observation on this topic, I would invite the inquiry to note that there is nothing to indicate that any of these important developments were motivated by any knowledge on the part of legislators or those responsible for the Home Office guidance of any specific problems regarding the conduct of undercover police officers, such as disproportionate interference in the privacy of others or misconduct issues of the type with which your inquiry is concerned. The point is simply that by the end of the Tranche 3 period, the landscape of legislation, codes of practice and guidelines concerning the authorisation and regulation of undercover policing was radically different to that which pertained at the start. A contrast which is, of course, even more stark today. So that is all I propose to say by way of opening the submission at this stage. Excuse me. Can I simply conclude by saying that the Home Office supports the inquiry's aims, as indeed does the Home Secretary personally, and is committed to her department continuing to cooperate fully with its investigations. She notes and welcomes your commitment to provide an SDS interim report and to continue to drive progress forward across all areas of the inquiry's work. She awaits the inquiry's findings and any recommendations you may make with interest. Given this is the last opportunity, or probably the last opportunity I will have to address you in a public hearing, may I also take the opportunity to acknowledge on behalf of the Home Secretary your many years of hard work in investigating the important issues with which this inquiry is concerned. So thank you very much.
Thank you, in particular for your kind words at the end, but as they recognise, the inquiry is a long and difficult process. We're doing our best. Thank you very much indeed.
Thank you, sir.
Sir, I'm told that Mr. Sanders is timetabled for 3:30.
Yes.
And it isn't going to be possible to bring that forward. So may we now adjourn until 3:30, please?
Certainly. Mr. Sanders, good afternoon. Your
Good
opening
afternoon,
comments.
sir. Are you hearing me okay?
I can hear you perfectly, yes.
Grateful, thank you. Shall I just go ahead then?
Certainly, please do.
Righto. So I appear, as you know, on behalf of the Designated Lawyer Officer Core Participant Group. We have filed a brief written opening for the upcoming Tranche 3 Phase 1 hearings. And I propose to be even briefer now in addressing you orally. Aside from Mr. Gunn and hopefully Mr. Phelan, there are no designated lawyer witnesses giving oral evidence in the upcoming hearings. And even Mr. Gunn and Mr. Phelan are strictly speaking Tranche 2 witnesses rather than Tranche 3 Phase 1 witnesses. The undercover officers who are giving oral evidence were, of course, managed by clients of mine, but we will address management oversight of all the open deployments when it comes to the Tranche 3 Phase 3 openings. So, for the purposes today, all I propose to do is address you on three short matters that correspond with the matters raised in our written opening. So that's first just a handful of general points, and then briefly to address you on the claims made by Mr. Francis, and finally to deal with HN81, who is a client of mine but is not giving oral evidence. First, sir, in relation to the general points, as we've set out in writing, we say it's important not to lose sight of the fact that there were more closed deployments in Tranche 3 than in Tranches 1 and 2, and notwithstanding the obvious failings of the SDS during Tranche 3, it also did some of its most challenging and valuable work during that era. This won't be in open, but it shouldn't be, in my estimation, shouldn't be forgotten. And it should always be borne in mind that the managers dealing with the officers that you're going to be hearing from before Christmas were also dealing with other matters and had a lot more on their plate than just the open officers. In addition to that, the Tranche 3 period, which certainly the upcoming phase, which is still pre-RIPA, was one where there were attempts by management to modernise the unit. So these included the introduction of psychometric testing for new recruits, psychiatric or psychological support for undercover officers and former undercover officers, the introduction of a mentoring scheme, which we've heard about, the introduction of performance indicators and customer feedback surveys, the introduction of designated cover officers for specific undercover officers, and changes to the way in which undercover identities were made. So at this time, I'm not seeking to minimize the issues that did arise, there were attempts within the unit to modernize it and to improve its systems. The second matter, as I've indicated, that I want to address you on, sir, is just the question of the claims made by Mr. Francis. As I've set out in our opening, I have more than 130 clients. A lot of them didn't come across Mr. Francis at all. Some of them did. Some more close had more involvement with him than others, and opinions vary. So I don't have a single position to set out about him, and I make no comment on his sincerity or motivations. What I do say is that there are reasons to be cautious about his claims, particularly the lack of corroboration from other witnesses and from contemporary documents. Also, what he has very candidly said about the impact of his deployment on him and the issues he has dealt with as a result, and his consequent feelings about the unit and about the police more generally. In terms of the accuracy or truthfulness, regardless of questions of why he's making these claims, we say that they are, a lot of them, a mixture of fact, fiction, and fantasy. And that's particularly the case in relation to three topics that I just want to touch on briefly now. First, sir, the claim that there were high-level concerns within the SDS, within the special branch, about black justice groups generally, or the Stephen Lawrence family campaign in particular, presenting a risk to public order, and in particular a risk of quote-unquote race riots. This claim is not supported by any contemporaneous documents. In fact, it is gainsaid by the SDS annual reports from the time. And those reports make clear that the main public order concern was with confrontations between the far right and the far left. So this is the era of just after the so-called Battle of Waterloo, the riots at Welling, the election of Derek Beacon, and so on. The second batch of claims relates to first an allegation that the Special Demonstration Squad was inquiring into visitors to the Lawrence family home in the immediate aftermath of the murder of Stephen Lawrence. And secondly, an allegation that there was an attempt to smear the Lawrence family or the Lawrence family campaign. So no other officer or document supports this at all. In fact, all of the evidence points the other way. Were it true, it would have been an extraordinary and unprecedented tasking. It's not consistent with anything else the SDS did. And the lack of records is also not consistent with SDS practice. And finally, it would have required not only an extraordinary degree of bad faith, but a degree of foresight about where the family campaign would lead, which no one in the Metropolitan Police had in 1993-94, which is when Mr. Francis claims he was given and undertook this tasking. And thirdly, the final matter are just the claims that Mr. Francis makes in relation to the Macpherson inquiry. And as we've set out, we say it's inconceivable that any SDS intelligence from 1993-94 would have been passed to Richard Walton in 1998. And what he says about a request that Sir William Macpherson be told about FDS tasking. Firstly, his Rule 9 statement says something different to what he said to the Ellison Review. And secondly, the timings in terms of a conversation with Keith Edmondson and his departure relative to the announcement of the inquiry and the inquiry chair, timings just don't add up. And we say in relation to all three of these matters that without commenting on why Mr. Francis is saying them, they are not true. Finally, sir, just in relation to HN81, who is a client of mine and is, as you know, not well enough to give evidence. And it's a very short point and one that's of great importance to him. He was not, quote unquote, a spy in the Lawrence family camp. And the claim that he was has had a devastating and unfair impact on him. That claim, that soundbite about spy in the Lawrence family camp comes from the Ellison Review. And that review, the report, defines what was meant by, quote unquote, camp as being those involved in the conduct and tactical aspects of the inquiry proceedings. It is in fact clear from the totality of the review and the evidence on all sides that the organisation infiltrated by HN81, which was the Revolutionary Internationalist League, or specifically its front organisation, the Movement for Justice, that it was not part of the Lawrence family camp and was in fact nowhere close to being so. HN81 never met or spoke to any member of the Lawrence family. And it's clear that from his evidence, but also from the evidence of the statements of Dr. Lawrence and of Suresh Grover, and from Baroness Lawrence's book, that Movement for Justice wasn't part of the Lawrence family account. Now, to be clear, sir, that doesn't mean that there are no issues for you about what ended up being recorded at the time, or the justification for this, or that there are no lessons to be learnt from what happened. It simply means that the headline about the spy in the Lawrence family camp, however attention-grabbing it may have been, was not true and is not fair on HN81. So those were the only points I wanted to address you on today.
Thank you very much. There is, as I believe you've been forewarned, an issue that I'm going to invite you to address today. And forgive me, it'll take me a little time to explain it, but not only you, but the wider public must understand it as well. It concerns HN 86. As you know, on the 30th of July 2018, I made a restriction order in respect both of his cover name while he was deployed and his real name. He was both an undercover officer for a short period and a manager of the SDS for a longer period. On the 4th of May 2018, the designated lawyers on his behalf made the following statements in the application for the restriction order which I made. I quote from, in the first place, paragraph 12C. It is in the public interest for HN 86 to be enabled to participate as fully as possible in providing evidence to the inquiry, and restriction would assist in activating this end by mitigating personal harm to HN 86 that might otherwise prevent engagement. Paragraph 14. The evidence that HN 86 is likely to be asked to give to this inquiry is likely to be of relevance to the inquiry's terms of reference. The Chairman will have to weigh carefully the public interest in disclosure of HN 86's identity against the risks identified above and the impact they may have with HN 86's capacity to engage with the inquiry process. Paragraph 16b, there is a public interest in mitigating the risk of harm to HN 86 in furtherance of the terms of reference to the inquiry, in light of the evidence that HN 86 may be asked to provide. I issued a minded to note on 23rd of May 2018, in which I said, amongst other things, the following. I infer from that statement, which is that which I've read from 12C, that he is willing to provide evidence to the inquiry, provided proper steps are taken to protect his health and welfare, including the making of a restriction order in respect of his real and cover name. I stated in terms that I thought that it was more important to receive his evidence as a manager than it was to reveal his identity to those who might have encountered him during his deployment. Those who instruct you notified the inquiry that he did not intend to provide any oral evidence to the inquiry. This prompted a short exchange as to what the reason was, in particular an inquiry by the inquiry team about whether or not the reason was health. That prompted the following response on the 24th of September 2025. We are not applying for HN 86 to be excluded on medical grounds. You either have or are about to issue judicial review proceedings challenging the decision made by the inquiry and put into effect to serve on him through you a notice under Section 21 of the Inquiries Act requiring him to give oral evidence to the inquiry in July. The inquiry has indicated that it would be perfectly content to receive his evidence remotely and in any manner which would make it easier for him to give the oral evidence that the inquiry seeks. As you know, his oral evidence concerns one of the critical issues which I must decide, namely what, if anything, happened about the Lawrence family campaign and those who supported it, and in particular whether there was any input by the SDS into the Lawrence family campaign and any wish to obtain evidence about it, principally but not allegedly exclusively, by means of the deployment of HN 81. There is an aspect of the evidence upon which there is only the word of HN 86 and HN 43 Francis about it. That is what HN 86 said to Mr. Francis during the repeated trips that they made into London from the area in which they both resided. The step or actuality of bringing judicial review proceedings in respect of the Section 21 notice must, I think, cause three groups of people to reflect upon what should occur. The first will be the Mayor's Office for Policing and Crime, who have been notified of what is about to take place, or what is taking place now in the inquiry's proceedings, as to whether or not that office will continue to fund, or has been asked to fund the proceedings which are designed not to enable the inquiry to fulfill its purpose, but to serve an alternative purpose, and the consequence of which will be to make it more difficult for the inquiry to fulfill its purpose. The second is me and the inquiry legal team, which will have to reconsider whether or not the restriction order made on the 30th of July 2018 should remain in place if HN 86 cannot be persuaded by any means to provide oral evidence to the inquiry. And the third group of people who need to reflect, and I want to precede what I have to say about that by these remarks. The designated lawyers have throughout been efficient, professional, have behaved with utter propriety in their dealings with the inquiry, and I hold them in high regard. But they, I think, may have to reflect upon whether or not, having made the statements in support of the application of HN 86 for the restriction order, can now properly play a part in bringing proceedings whose consequence is to frustrate the purpose indicated in their application. As I say, I make that remark to invite them to reflect rather than by way of criticism. I do not make any such criticism. I invite your response. If you want time to reflect upon it before responding, then by all means take half an hour now to do so. But if you are able to respond, having been forewarned of the gist of what I might be able to say, then I invite you to do so now.
So there's one brief point. HN 86 didn't overlap with HN 81. I don't know if that was just a slip on your part, but I just wanted to clarify that. So he wouldn't be able to assist with anything to do with HN 81 or matters that took place at that time?
He was let me reflect carefully upon what I want to say. Nothing that I've said should be taken in any way to affect the position of HN81. I have made the order that I have done so as to preserve his health and well-being in circumstances that have been explained to me. As you know, that has caused a certain amount of comment from other parties in the inquiry, but I have nothing further to say about that. The thrust of my comment, observations to you, concerns the allegations that are made by Peter Francis and the response to those allegations that has been made by HN86 in the light of the comments in his application to which I've drawn your attention.
Yes, so at the time of the restriction order application, HN86 said, and I don't have the words in front of me, but words to the effect that he found it very difficult to think about the prospect of giving oral evidence to the inquiry. But it is correct that he was keen to cooperate and contribute so far as he was possibly able to do so. And he has, as you know, from the country where he resides, he's produced a Rule 9 statement answering written questions from the inquiry in the same way as other overseas designated lawyer officers did. So, for example, HN33, HN88, he's been invited to give oral evidence and he has declined to do so. The question in the judicial review is whether or not the inquiry, as a matter of law under the Act, has power to compel HN86 to leave his home and his home country and return to the UK and give oral evidence. Since 2018, I think obviously a number of years have passed. HN86 is now older than he was. He has suffered two serious conditions with his physical health. He doesn't feel able to give oral evidence, and that's why he's declined to do so. So in terms of doing everything he possibly can, he feels he has done everything he possibly can. The legal question with regard to your power under Section 21 of the Act to compel someone who is overseas to return here and give oral evidence or to give evidence via a video link as a fallback is a live issue. And my understanding is you accept that it's arguable and that the claim should have permission and should be resolved. And we will have to see where we are, but in the light of the outcome of that, I appreciate it's a disappointment for you and for the inquiry and for others. Equally, I've spoken to HN86 and all I can do is I can advise him and take his instructions and represent him. And the same goes for my instructing solicitor and her team. These are not our decisions, but it is our position and has always been our position that the inquiry has no power to compel overseas witnesses. We understood it was your your position. It's a fairly orthodox position across inquiries generally. There's no point us trying to litigate it now, argue it out now. But that's where we are. In terms of funding, there is a public inquiry into undercover policing, and the consequence of that is that people who were involved in it are or participants or witnesses, and they're entitled to representation. And a corollary of that is that there may be circumstances where there will be a disagreement about the law and a need to have that resolved by the High Court. That's simply due process and the rule of law. And we've hit this point, or certainly my team and the inquiry have hit this point 3 times before. I think this is our 3rd judicial review. And there's a disagreement about the law, and it's resolved by the court or by way of settlement. That's, in my submission, the appropriate way to proceed.
I don't think there's any good purpose in us exchanging views further now, but I'm going to ask Mr. Skelton for the Commissioner if he has any observation to make about the issue. Could Mr. Skelton be invited to come to the screen, please?
So can you hear me?
Yes, I can.
Thank you.
Mr. Skelton, I'm so sorry. I was looking away from the screen when you came on. Apologies.
Thank you, sir. So you'll be aware that the correspondence relating to the judicial review was passed to the MPS late last week.
Yes.
And in those circumstances, I haven't had the opportunity to take instructions from the Commissioner, nor have I had the opportunity to apprise myself of the full background, some of which you have outlined today, to the original restriction order application, the basis on which it was put, and HN 86's present circumstances, which Mr. Sanders has just intimated are relevant to his personal decision to not provide oral evidence remotely from wherever it is he lives. So in those circumstances, absent instructions, so I don't think I can really assist on whether or not there is a conflict or what position the MPS might take in respect of the judicial review, or indeed whether funding should or shouldn't be continued. I'm sorry to give rather a non-answer, but I think I have to maintain my cautious approach until I get instructions from the Commissioner.
I entirely understand that. If and when you do have instructions from the Commissioner, could you relay them to the inquiry?
Yes, of course.
Thank you very much indeed. I might ask you to do so on screen if you are able to obtain them in the very near future.
So I don't think it will be while we are going through the opening statements, because it takes a little time to get some access to the Commissioner, as you appreciate.
Of course, he has many other tasks. I readily appreciate that. But it may be that I will ask you to come onto the screen, or indeed if you're here in person, to say something in person about the issue when you have instructions.
Understood. Thank you.
But in any event, I'd be grateful if you communicate it in writing, if it need be, or by email, or however it's done electronically, before that occurs.
Thank you. I will.
Thank you. That, I think, concludes today's business, does it not?
It does, sir.
We resume tomorrow at 10, when we will hear submissions from a number of court participants.